Hello everyone, and welcome to the June 2023 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our June 2023 topics include, of course, a case law update. I have some interesting cases for you guys today. We'll start with Harris v. Alson. It is an unpublished opinion issued recently on May 18, 2023. Next up, we'll have the case of Melvina Howard v. LM General Insurance Company. This is a soon-to-be published opinion. And then lastly, we have Morissette and Central Home Healthcare Services v. Indiana Harbor Insurance Company. And this is, again, or also an unpublished opinion. This one was issued in November of 2022. Then for our trending topics in PIP litigation, I wanted to discuss motions for summary disposition and specifically this unpublished opinion of Maple Manor Rehab Center of Novi v. Allstate Insurance Company. This one was issued recently, March 16, 2023. First up, we have the case of Harris v. Alson. Again, an unpublished opinion issued May 18, 2023. And this case centers around the Supreme Court's threshold injury analysis. As we all know, the McCormick v. Carrier decision. Here, a plaintiff who demonstrates an objectively manifested impairment of an important bodily function that has great value or significance to the specific plaintiff that affects the plaintiff's general ability to lead their normal life may survive summary disposition. Now, the important takeaways from this case is that it does not necessarily have to destroy the plaintiff's total ability, and it does not matter how long the inability or impairment actually lasts, as long as it was there. Now, this slide centers around the actual MCL 500-3135 Section 5 that defines what a serious impairment of a bodily function means. Now, objectively manifested, meaning it's observable or perceivable from actual symptoms or conditions by someone other than the injured person. This cannot be subjective, it must be objective. And that impairment has to be of an important bodily function, which is a body function of great value, significance, or consequence to the plaintiff, him or herself. And that impairment, that objective impairment, has to affect the injured person's ability to lead his or her normal life. And here, that means that it has to have had an influence on some of the person's capacity to live their normal life, the normal manner of their life. And although temporal considerations may be relevant, there is no temporal requirement for how long an impairment must last. This examination is inherently fact and circumstance specific and circumstance based to each individual person or each individual plaintiff. And this case essentially says the analysis of that must be conducted on a case-by-case basis regarding each specific plaintiff before and after the incident or accident. Now, in this case, the panel analyzed MCL 500-3135 and the McCormick v. Carrier framework. Ultimately, the panel opined that plaintiff's treaters here support her claims of objective injuries, including traumatic spondylopathy within the plaintiff's neck, which was a flattening of her cervical lordotic curve, decreased range of motion, and an elevated left shoulder as a result of a muscle spasm. Next up, the panel did find that records suggested that plaintiff's impaired bodily functions were important to her specifically, given that they impacted her ability to walk, participate in recreational activities, and perform certain physical tasks at her job. The court also found that the plaintiff presented evidence from which a trier of fact could find that her impairments affected, but not necessarily destroyed, her ability to lead her normal life. The panel highlighted that the fact that the plaintiff missed 8 days of work due to the accident and was disabled from household chores for over a month was important to this case, and that the plaintiff testified that she could no longer bowl or play softball, which she enjoyed prior to the accident. Again, it did not matter how long this impairment took place, and it didn't matter if the impairment did not, or it didn't matter if the impairment totally destroyed or just affected her ability to lead her normal life, as long as it was affected in some aspect. Next up, we have the case of Melvina Howard v. LM General Insurance Company. Again, this is a soon-to-be published opinion, but here the Court of Appeals affirmed the trial court's order denying defendant LM General Insurance Company's motion for summary disposition. Here, the issue presented to the Court of Appeals was whether rescission of a policy as to PIP and UIM coverage should be granted to a no-fault insured when there is more than one named insured and the injured insured did not participate in the actual fraud. Now here on appeal, LM asserted that Plaintiff Howard's vehicle was registered to a different address than the address that was on the policy, but there was no presented evidence to support this allegation. As such, it did not affect the Court of Appeals analysis, as the only admissible evidence in this case that defendant offered was the misrepresentation related to the insured's UConn as its basis for rescission. Now, just by way of background, which is important to this specific case, Plaintiff Howard was injured in a motor vehicle accident while driving her Mercury Mariner, which was covered by an automobile policy issued by defendant in 2014. There were no issues regarding the issuance of the policy nor any renewals after the issuance of the policy. But in April of 2019, just before the loss, Plaintiff Bartell contacted defendant to add a UConn to the policy and indicated that the UConn was garaged in her home. Later, it turned out that the UConn was not garaged at the policy address, but garaged at a relative's home. If defendant had known, they would have denied coverage for this, and therefore, defendant retroactively rescinded the entire policy back to the date the UConn was added. As a result, Plaintiff Howard would not receive PIP or UIM benefits arising from the subject loss. But remember, Plaintiff Howard insured the Mariner, not the UConn. Now again, during litigation, defendant did not provide any evidence to show that Plaintiff Howard was complicit in the misrepresentation of the UConn, but nonetheless moved for summary disposition because they rescinded the policy back to the addition of the UConn, and the accident took place after that addition of the UConn. Now here, the Court of Appeals utilized the 5 non-exclusive factors outlined in the case of Farm Bureau General Insurance Company of Michigan v. Ace American Insurance Company to determine whether Plaintiff Howard was considered an innocent third party in this matter and whether rescission applied to her, and ultimately the court decided that rescission did not apply to her. Next up, we have the case of Morissette and Central Home Healthcare Services, the Indian Harbor Insurance Company, and Contrell Mitchell, which is an unpublished opinion issued back in November of 2022. Now, this case gives guidance into how courts will handle arguments for proper notice under MCL 3145 Section 1, specifically when notice is provided to named insured. Now, in this case, the Court of Appeals did not find any exception for plaintiff's failure to provide notice to defendant and ignored the argument that notice to defendant's insured is comparable to providing notice directly to the insurance company. Now, in further cases involving this same issue of notice, defendant insurers should understand that courts will not accept the notion that providing notice to an insured constitutes proper notice to an insurance company absent additional evidence. So it cannot just be automatically assumed that providing notice to the insured is the same as providing notice to an insurance company. Now, by way of background in this case, the plaintiff, Morissette, was working as a driver for Lyft when the accident took place. She was rear-ended by an uninsured motorist, and that was defendant Mitchell. And then after experiencing pain in her neck and back, she applied for uninsured motorist coverage and also PIP coverage through her insured AAA. AAA thereafter denied benefits, and plaintiff subsequently filed a lawsuit. Fast forward, the trial court granted AAA's motion for summary disposition due to the business pursuits exclusion in AAA's policy. Now, during her litigation with AAA, plaintiff became aware of the existence of defendant Indian Harbor Insurance Company's policy, who provided no-fault insurance to Lyft drivers or Lyft vehicles. Plaintiff then filed her complaint against defendant in July of 2020, which was more than a year after the accident. Thereafter, defendant Indian Insurance Company Indian Harbor Insurance Company filed a motion for summary disposition on the basis that plaintiff's claims were now time barred under MCL 500-3145, Section 1, arguing that they didn't receive notice until March of 2020, more than 1 year after the accident, and that notice was a verbal communication from plaintiff. Now, in response, plaintiff argued that she notified defendants insured Lyft on the date of the accident. Now, ultimately, the Court of Appeals found that notification to an insured does not necessarily constitute proper notice to an insurance company, absent any additional evidence. So just that one specific thing does not necessarily constitute the proper notice. Now, moving on to trending topics in PIP litigation, we have up the case of Maple Manor Rehab Center of Novi and Maple Manor Neuro Center, the Allstate Insurance Company. And this is an unpublished opinion that was recently issued in March of 2023. This case centers around MCR 2.116C4 that indicates in order for a party to overcome summary disposition under a C10 motion for summary disposition, it must not rest on mere allegations or denials, but must set forth specific facts by affidavits or other evidence to show that at a bare minimum, there's a genuine issue of material fact for this case to proceed forward to trial, for a jury to decide, or for a judge to decide if it's not a jury trial. Now, as we all know, a motion brought under a C10 motion, MCR 2.116 C10, tests the factual support for a claim based on those affidavits, pleadings, depositions, admissions, and other evidence submitted by the parties. And that's the case of Cloblentz v. Novi. Now, this evidence is viewed in the light most favorable to the non-moving party, which a lot of times we see is typically plaintiff. Now, under C10, except as to the amount of damages, there must be no genuine issue as to any material fact, and the moving party is entitled to a judgment or a partial judgment as a matter of law, not as a matter of fact. Now, in this specific case, plaintiffs brought a medical provider collection action seeking payments for services it rendered to the claimant, Newell. Allstate argued that the Neuro Center provided Newell with medical services, and because there was no dispute that the Neuro Center was an unlicensed entity, it could not legally bill for those services that it provided to the claimant. Now, here the trial court agreed, finding that there was no genuine issue of material fact that Neuro Center provided medical services to Newell. And since it was undisputed that Neuro Center provided those services, and it was also undisputed that the Neuro Center was not licensed, summary disposition was entered in favor of Allstate. The trial court therefore denied plaintiff's motion for reconsideration and entered a final order dismissing this case. Now, after reviewing all the submitted evidence, and here both parties submitted numerous medical bills, affidavits, deposition testimony from another case brought by plaintiffs involving the same issue, and they produced several other documents, the Court of Appeals eventually concluded that there was a genuine issue of material fact as to whether Neuro Center provided any medical services as to the claimant. The court held that even if the trial court properly concluded that Allstate met the summary disposition burden by submitting evidence showing that Neuro Center was the rendering medical provider, the records revealed that Maple Manor did not rest upon mere allegations or denials, but by affidavits and other evidence set forth specific facts showing that at a minimum there was a genuine issue for trial. Specifically, plaintiffs argued that the name on the medical record was not necessarily the legal provider of the services, but that Maple Manor could have provided those services and not the Neuro Center. Now, here the court concluded that at minimum there was conflicting evidence on the precise issue of who provided the services and was the providing party licensed. So because of that, this case should have survived summary disposition. Now, the court here highlighted MCR 2.116G4 that says that a motion under C10 must specifically identify issues as to which the moving party believes there is no genuine issue as to any material fact. When a motion under C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavits and other evidence, set forth specific facts showing that there is a genuine issue for trial. Now here, the Court of Appeals emphasized the relatedness between a motion brought under C10 and the requirements set forth in G4. Now, you cannot simply rest on the mere allegations or denials in response to a motion for summary disposition, and you must set forth additional evidence or affidavits. And that is all I have for you guys today. Again, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Please feel free to contact me with any questions and or concerns. Thank you.